So now we will start the discussion on the matter. And for this, I invite our first discussant, Ms. Lisa SPEER. Ms. SPEER, a Master of Arts degree from Yale University, is the director of the International Oceans Program at the National Resource Defense Council, a US-based NGO that utilizes science, policy, and law to address the climate crisis, protect public health, and preserve nature. With a strong commitment to environmental conservation, Ms. SPEER has been actively involved in the development of the BBNG Treaty since its inception. She led the High Sea Alliance work on the environmental impact assessment provisions of this treaty. Her work is currently focused on promoting the rapid ratification of the BBNG agreement and advocating for the effective utilization of the AIA provisions to enhance the assessment and management of human activities in areas beyond national jurisdiction. Ms. SPEER's dedication to environmental protection and her deep understanding of the BBNG agreement make her a highly respected figure in the field. You're invited to the floor, Mr.
Thank you so much, Judge KULYK, for those kind remarks, and thank you to the organizers for what is really an amazing setting here. A lovely dinner last night, beautiful surroundings, and even great weather. Yeah, so thank you very much for that. And it's a special pleasure for me to be here in Korea. My dad, my father, served here as a medic in a mobile army surgical unit in the early 1950s, and he regaled our family over the years with many stories about Korea, so it's quite special for me to be here today. So I would like to just offer some responses and some thoughts from an NGO perspective. As Judge KULYK said, I've been involved since I had a lot fewer gray hairs and wrinkles around my eyes in this process, and have focused on the EIA provisions, which started out being somewhat of a sleeper section of this agreement, but ended up being, I think, very robust. The EIA provisions part is the longest part of the BBNJ agreement. It has 12 articles. And when we started out with this process from the NGO perspective, the goal was to both operationalize the general requirement in Section 206 of UNCLOS, but also to address the existing very fragmented, inconsistent regime for assessing and managing human activities in areas beyond national jurisdiction. There is a huge disparity between the practices of different existing bodies. Some are strong, some are weak, some bodies have no environmental impact assessment requirements at all. And so one of the major objectives from our perspective was to update, to modernize, and to make more consistent across sectors assessment and management requirements. And lastly, one of our principal goals was to give the international community a much greater opportunity to understand what is happening in areas beyond national jurisdiction and the impacts of those activities, and to give them a greater say in decisions that could affect them as the high seas belongs to all countries and not just the countries that are out there and able to conduct activities. So rationalizing, updating, and strengthening the existing system of EIA practices across sectors was really important. We didn't get there. As René noted, the current fragmented system was left largely intact through the various exemptions that exist throughout this part. And it reflected the overall reluctance of delegates to interfere in any way with the operation of existing bodies. And René referred to that yesterday in the MPA context, the same was true in this context as well. I think, from our perspective, the failure to address the jumble of inconsistent EIA requirements across sectors is the single biggest failure of Part 4. But having said that, there are nevertheless some very important steps forward that I'd just like to briefly touch on. First, some provisions of the agreement do apply to existing activities. States must monitor, as both René and Professor CRAIK indicated, they must monitor their activities and report the results of their activities through the clearinghouse mechanism to the broader international community. The call-in mechanism that René described for screening also applies to the as Neil referred to, the post-approval process. So a party can register its concerns about the effects of an approved activity, and the STB can make recommendations on that. And lastly, the objective in Article 34 applies to existing activities, along with its much weaker companion language in the decision standard articulated in Article 37. And that requires that the objective in Article 34 is to, quote, ensure activities covered by this part are assessed and conducted to prevent, mitigate, and manage significant adverse effects. This is a real step forward, in part because significant adverse effects have been elucidated in a variety of different international contexts, and we know much more about what constitutes an significant adverse effect than we do, for example, of what constitutes a significant effect under the UNCLOS standard, or for that matter, the minor or transitory standard. A second important step forward, I think, is the consideration of traditional knowledge and of indigenous peoples and local communities. There are requirements sprinkled throughout this part to consider this kind of knowledge, and while there, I think, will be challenges in implementing this, I do think it is an important step towards giving voice to a group of people who have so far been largely excluded from any kind of role in the decisions about what happens in ABNJ. A third, I think, really important element that doesn't get a lot of attention is something René mentioned, is that the STB may provide comments on EIAs that are prepared under national processes for activities within national jurisdiction. And I think this is going to be important, increasingly important as time goes on, and as we see we have a growing understanding of how effects can easily cross over boundaries. A fourth and very important step forward is, of course, all of the provisions that apply to new activities on the high seas that are in the area beyond national jurisdiction. That is, activities that are not covered by existing regulations. There's very detailed process and content requirements that are applicable, and I think that that does a number of things. First of all, as we begin to face more and more calls for climate mitigation strategies involving the ocean, these provisions will be incredibly important, and we can see these already they're coming at us pretty quickly, and I think that will accelerate as the climate emergency continues to deepen. The other piece of this puzzle, I think, for new activities is that the whole process of evaluation gives much more transparency and a much bigger say to potentially affected states. and as well as communities. And so the provisions that do apply to new activities are singularly robust and represent the most modern elucidation of what is required in EIA that is now out there. And over time, I think these new requirements will seep their way into existing bodies. That's the hope, because they are the most modern, and because there's an increasing recognition that these kinds of robust assessments and management requirements are really essential to appropriate ocean management. Capacity building also received a boost, not as much as one might hope, but through provisions that allow the possibility of joint EIAs to be conducted by several different countries, and also by the provision of a roster of experts that will be available to assist countries that lack capacity to develop or review EIAs for activities conducted under their national jurisdiction or control. Unfortunately, the access to the roster of experts does not apply to, is not available to developing countries for reviewing EIAs prepared by others. And that is going to be a real challenge for many developing countries. So those are a few of the big steps forward that we see. I'd like to just address two big challenges looking ahead. The most important immediate challenge is to get to 60 ratifications as soon as possible. And this means really continuing to shine a light at a high political level in as many fora as we possibly can. So just as an example, my organization worked with the government of Belgium to host a high-level ministerial event around the UN General Assembly, where we had 23 ministers, a prince, and 2 movie stars. And the whole idea was to try to maintain the momentum that we generated through the adoption of the treaty in June through to the GA and then beyond. So, for example, we understand that at least one prominent head of state will refer to the need for swift ratification in his remarks on Leaders' Day in the opening of COP28, the climate COP, and use that as an example of an important step the international community can take to enhance the resilience of the ocean in the face of climate change. There will be other opportunities coming up in the coming year. Our ocean in Greece in April, the conference of the preparatory meeting for the UN Ocean Conference, which will take place in Costa Rica in June, and then the next GA. So continuing to have this drumbeat, trying to maintain the political momentum that we've built up through adoption of this agreement at a very high level. And at the opposite end of the spectrum, there appears to be a real need to help governments prepare for ratification. So last week, NRDC partnered with the government of the Philippines with the support of the UK and Australia to convene a workshop for a subset of ASEAN countries. And the goal of it was to help the Philippines and other countries understand what's in the agreement, what are their obligations under the agreement, and what's in it for them. Why should they ratify? And it was totally clear to me that there is at least in that group of governments, there was very little awareness of the BBNJ treaty at the working level. And these are the people who are going to have to write the legislation. They're the ones who are going to have to make this happen. And ratification is not an easy process. And I think it's going to be really critically important for us as a community to develop a plan and a program for helping countries really understand what the BBNJ treaty is all about. There's just by by way of explanation, there's also another workshop that my organization is supporting that's taking place in Abuja today. And it involves 12 of the 15 ECOWAS countries of West Africa. Same situation. There's very, very little understanding of what's in the BBNJ agreement. And a concerted effort is really required in other regions of the world. We understand that Douala is going to be doing some workshops, but we don't know when or where or anything really about that. And so if we hope to have ratification of this agreement anytime in our lifetimes, I think there will be a concerted effort that is needed. So the second big challenge is one that I think Professor CRAIK really highlighted, and that is the institutional structure needed to adequately implement this agreement is complex and large, and it will take time to develop. And rather than wait to the first COP to do that, our view is that it's critically important that a PrepCom be established quickly and funded quickly so that we can begin to work on the pretty significant array of institutional structures, the procedures, et cetera, so that when the COP first meets, it's ready to go and doesn't have to spend yet another decade trying to deal with all of the institutional requirements. And I often, when I talk about the institutional structures, people always yawn. They think, oh, procedures, boring, boring, boring. But I like to quote a representative from Michigan, Representative Dingle, used to say, you write the substance, I'll write the procedure, and I will mess with you, he used a different term, every time. And it's really true. So getting the procedure right is really important. It may not be very sexy, but a significant investment, I think, is required there. So I've run out of time, and I will leave it at that. Thank you.
Thank you, Ms. SPEER. Our second distinguished discussant is Professor Byung-Chun, who currently serves as the president of the Korean Environmental Law Association and has previously held the position of president of the Korean Review of International Law. Professor Sohr is the chief editor of the Journal of International Law Association, and we are fortunate to have his expertise and perspective in this session, as his wealth of knowledge and experience will bring invaluable insight into our discussion. The floor is yours, Professor Sohr.
Thank you, Excellency Judge KULYK. I'd like to also thank you for the Minister of Foreign Affairs, the Republic of Korea, and also KSIL, the Korean Society of International Law. We are very familiar with the very short words, BBNJ and EIA. So KSIL stands for the Korean Society of International Law. For the hosting this wonderful international conference of the Law of Sea. And I also like to say it's my great honor to be here as a discussant with excellent judges and distinguished professors, scholars, and experts. I would like to also appreciate our two speakers, Dr. René LEFEBER and Professor Neil CRAIK, and Ms. Lisa SPEER, the NLDC I admire. I believe the establishment of the basic procedure of the EIA in the BBNJ agreement is quite important in the history of the international environmental law, I think. As you may notice, the EIA is the key, one of the very important key system of prevention principle, which is one of the customary international law. We have international EIA system in ASF Convention and the Antarctic Treaty, the protocol and guideline. However, BBNJ agreement set up the EIA, system in the international rules and procedure in the agreement. I think this is a really great big step forward. But as the saying goes, The devil is in detail. So we have a few things to note when it comes to implementing the BBNJ EIA system. And we need to come up with the code of conduct on those kind of issue, taking account the practice of contracting parties in this, the thing that I mentioned, I will mention. For example, the requirements for the initiation of the screening process in EIA. Our two speakers and discussant mentioned about that. I think among the EIA process, screening, scoping, evaluation, etc., one of the most important thing is the screening and initiating, because it is the first step in the deciding whether to do the environmental evaluation or not. The Article 30 to stipulate on that issue, the threshold and factors for conducting EIA. It mentioned the substantial pollution of or significant and harmful change to the marine environment. I'd like to discuss on the definition of this, what is substantial pollution and what is significant change. What difference between those kind of words, or between the substantial and significant? I'm Korean, I'm not an American. English is my mother language, so I'm not sure. And I think no one takes it significantly, but it's just a really substantial issue for the environmental lawyers. 2001 International Law Commission, the draft article on prevention of transboundary harm from hazardous activities, mentioned about the definition of the significant in the commentary. It said, I know this definition is not the legal stuff, more than it's factual. We need some deciding of the factual stuff. However, the ILC provide some clue on it. It said that significant is something more than detectable, but need not to be the level of serious or substantial. So ILC suggests the level like detectable, the minor, and significant and substantial. So we need to elaborate on those kind of some degree on the words in practice when we decide we need the EIA or not. It's quite difficult and very practical matter. But I believe the significant is more than detectable. So if we think it's more than detectable, and even though it's less than serious, we have to go on the EIA process. For example, the U.S. law, the NEPA, National Environment Policy Act, that's correct? Yes. In Article 102, it's a legal base of the EIA. It mentioned the significantly affecting the quality of the human environment, any federal action, then it goes on the EIA. So significance means, I'm not sure the practice of all the states, but in Korean domestic environmental law also, we have some list of the activity that is necessary to have the EIA. So I think one of the standard, the code of the conduct in the international society is what is significant one. We have to elaborate on that issue. And who will judge this point? In the end, Dr. Lefebvre mentioned of the 5 mechanisms. And in the end, I think the national party, the contracting party, will judge with this, with the help of the STB, the scientific and technology body or under the COP. And if there is a problem with this, it will go to the International Tribunal. I think the EIA is very technical and very scientific area, very difficult. So I think STB, the expert group for the scientists and technicians, they have to play a critical role in the running the EIA, especially the deciding this matter. This is a significant, substantial. Do I need the EIA? Yes, still international law focus put the priority on the sovereignty. I know. We like to, okay, the states has to authority to decide on that. But my major is transboundary environmental harms risk. And I believe sometimes the sovereignty is a really big and high barrier to overcome to handle the transboundary environmental damages. So I think the STB should take some great role in this expert role in this matter. Today the LEFEBER introduced 5 mechanisms, and also Neil Craig speak about the function of the institution. So in particular, I'd like to ask what do you think of the strengthening of the role of the STB relating to the registration call mechanism, and also the auspicium, the conference of the parties. Moreover, I like to think about the little practical thing. SEA, the Strategy Environmental Assessment. Despite the importance of the Strategy Environmental Assessment, SEA, it is quite regrettable that the agreement does not stipulate on the obligation to the conduct of the SEA as a binding obligation. And the other thing is, practically, who make a EIA statements or report? The states or operator? Or even though the state is the main body of the EIA, it's highly likely that the operator of the project will make a contract with a professional EIA agency to prepare the EIA. So, therefore, the role of the governments, of the management, to ensure that the company do their due diligence to produce the report. I don't like to say this, but still so many countries, the EIA made by the agency, the private agency, then it's just, the conclusion is, it's good for the operation, just good for the project. So I think that is a really important thing. My final comments is really, I'd like to appreciate all the hands working on the establishment of the BBNJ agreement, because this is a really big step to develop our international environmental law. But we have to focus on more detailed stuff to implement this EIA agreement to protect our marine environment, not only sustainable use, protect and preserve the marine environment. Thank you.
I
I thank Professor Soor. So now the floor is open for the question. Yes, please.
Thank you, Chairperson. My name is Kun-Wan Lee, and I'm teaching public international law at Seoul National University, and I'm at the same time working for the UN International Commission. Well, I'd like to express my sincere thanks to all these rich and enriching presentations and discussions. I'd like to direct my question to Mr. LEFEBER. Well, it doesn't goes to the question of EIA, but in your presentation, well, I was intrigued by the specific case of Sao Paulo, and especially your discussion of sovereign immunity of that ship. And in that connection, let me just raise two questions. Well, first of all, this may be a rather minor point, but at the same time, it could carry fairly significant or maybe substantial practical implications. So first, my question is, when the Brazilian Navy or maybe the Brazilian government decided to sink this decommissioned warship, what was its legal status? Can you regard it as warship even after you decided to sink the commissioned ship? That'll be my first question. And of course, it has to do with the definition provided in Article 29 of UNCLOS. And the second question is, there's a point of clarification, but sovereign immunity, you can find other clauses dealing with sovereign immunity in the UNCLOS. And so in that regard, I think we have to clearly distinguish between immunity and probably quote-unquote impunity, right? So in that case, I think you cannot, the ship, if it were regarded as a warship entitled to sovereign immunity, then it is immune from enforcement jurisdiction by the coastal state or any other state. But it doesn't mean that the state, flag state, is exempted from substantive responsibility under international law. So I'd like to just ask for your maybe elaboration on these questions. Thank you.
Thank you. Could you respond? Yes.
Yeah. Thank you for that question. It's an important question. I think we should directly submit it to the International Tribunal for the Law of the Sea so that they can answer it. I thought about that, and I was wondering whether I should mention it. I thought, well, let's see what the response is from the room. And to be frank, I cannot answer this definitively. What is the legal status of a ship at the time of the sinking? And this is a deliberate act of sinking after decommissioning. So if you compare it to warships that have sunk and have become war graves, I think that many countries consider those war graves, the ships that are sites of war graves, to still be ships that are warships and therefore enjoy immunity. So there is, according to that line of argument, but then of course it sinks at the time that it's still a warship, then I think immunity still applies according to many states, including, I might add, the Netherlands. And I agree with you that immunity should not lead to impunity. But I think this is a very difficult one to answer. So I'd like to hear the views of the judges on it. And we have so many of them here, and they might be confronted with the question in the future. But I'd put, at this point in time, still I put my money on immunity at the time of sinking, even after decommissioning, because that makes it a bit more controversial, and you could argue it both ways, but that's where I would go at the moment.
I thank you. I could just assure you that don't expect the response from judges before the question is submitted. And before the audience is thinking about other questions, let me hijack the role of the moderator and have a question to both of our speakers. And it seems simple. I wonder what's in your view is the key feature which distinguishes the procedure and the requirements concerning environmental impact assessment under the BBNG agreement in comparison with other existed agreements or national requirements, and maybe this feature, which I assume a positive one, in your view would be appropriate to introduce or change in this existing mechanism.
Shall I go first? Well, I think that I cannot speak for the legal systems of in the world of all states. But what I try to demonstrate in my presentation is that many domestic regulatory frameworks do not apply at the moment to activities beyond national jurisdiction in relation to environmental impact assessment. So the big change that the BBNJ agreement will bring is that it will have to be implemented in domestic law. So I think that is very important. And the second one is, and I alluded to that as well, is that existing organizations and bodies and frameworks and instruments at the international level will have to look at the BBNJ standard. I think the BBNJ agreement sets a standard that will now have to be followed by other international organizations and frameworks and instruments. So that's what I meant, that is what I was trying to convey when I made reference to the International Seabed Authority. They will have to evaluate their draft regulation and the exploitation regulations on environmental impact assessment and assess whether that meets the standard that has now been set by the BBNJ agreement. And I could go on. I mean, I think it's the same is true for regional fisheries management organizations. The same is true for the London Convention, London Protocol. I did not have time to address that, but there's a similar issue. If you look at the assessment framework of the London Convention, London Protocol, it's very poor in comparison to the BBNJ agreement. So they have to step up. Over to Neil.
I actually think the oceans assessment framework under the London Protocol amendment is actually quite fit for purpose. I think it's quite an interesting document because one of the things it does, and it's very particular to marine geoengineering, is that it not only requires an assessment of the environmental impacts, but it requires consideration of the scientific merit of the experiment itself. And I think that's particularly important. And the actual test under the London Convention is it a legitimate scientific experiment because of the HIDA problem that they had with that strange experiment off the west coast of Canada several years ago. I guess in terms of other processes, I was intrigued by what Lisa said about some of the capacity issues, and I think one of the things that we've seen in Canada, particularly because we have a constitutional duty to consult Indigenous people, and that is largely implemented through our environmental impact assessment system. We have a robust system of intervenor funding to support those groups in that process because they require access to expertise in order to effectively participate in that process. And I think thinking about a fund that would provide some access to expertise and an exchange of expertise may be one of the ways in which to build some capacity. I think that will be really important for the effectiveness of the BBNJ process. I can't think of an international analog for that. I think the other element that you see in the deep seabed mining process is some potential for peer review of environmental impact assessment, so independent peer review. Now, it's a very different context, but again, there may be some room for that as well. So I'll leave it at that. Thank you.
Thank you. Judge Brown, you indicated that you wanted to question.
Thank you very much, Judge KULYK, but I appreciate the notion of Korean time, and I also have learned over life that you do not detain persons when the next item on the agenda is a luncheon. So I withdraw my request for the question.
I don't see whether there is any wish for the question. Then it means that we approach the end of our session. I wish to thank the speakers and discussants for their very interesting presentations, their thought-provoking view. I think it's clear that we need to continue the dialogue, and the effective implementation of the relevant provisions definitely required the comprehensive and collaborative approach, including the interest of all the stakeholders from the industries, NGOs, states, etc. And I wish all of us don't forget that actually at the foundation, the international law of the sea, which is the cooperative basis for all that endeavor, including this implementing agreement. Having said that, I wish you all the best in your endeavors. I hope we will have another several interesting sessions, but as far as this part of our conference, I think it's adjourned. Thank you very much.
Thank you, Judge KULYK, for your moderating. Appreciation also goes to our speakers for sharing their insights and experiences. So let us give another big round of applause for all the speakers and our moderator, Judge KULYK.